malevolent forces.
I'm going to call Dennis O'Rourke.
Mr. Chairman, New Zealand First does support both parts 1 and 2 of the bill, with an exception which I'll come on to and which we've been debating tonight. Part 1, of course, with its reference to excusals and disqualifications, I think and we think is pretty sensible. The new Section 14D disqualification relating to people on home detention over 3 months being disqualified is sensible, and under 3 months a discretion for the judge also is very sensible. And secondly, the new Section 15A1 providing for excusal because of the state of a person's health is also sensible and would be good law. And thirdly, the new Section 16, giving a judge a discretion where there's a conflict of interest or grounds of conscience, is also good law. However, Mr. Chairman, it is the new Section 15A2 which we think isn't good law and should not proceed. And that, of course, is the provision which provides for right of excusal on application for a person over 65 simply because of their age. And I take notice of the fact that the Minister has an SOP in which would allow a person to go back on the jury list and then go back off it, then go back on it again, I don't know how many times. And that doesn't seem to be very sensible to me. But fundamentally, New Zealand First does oppose that part of the bill which provides for an application for excusal as of right for a person over 65 years of age. And the first reason, and there are 5, does relate to ageism. Now, the Minister says that it's not ageism. Well, how on earth could a provision which is entirely based on age and on no other criteria whatsoever, be anything other than ageism? Because it is age-only based, and that is wrong in principle, and for that reason alone should not proceed. And secondly, Mr. Speaker, it is irrational to do that because people 65 years or over are actually better equipped than people younger than that to take on this role. And they're better equipped because they have a lifetime of experience to rely upon. And as Leanne Dalziel quoted from the report of the committee, it says, "We consider that the life experience of older people is of significant value to society, and we would encourage those who are able to do so to continue to undertake jury service." So the committee thinks that 65-year-olds and over should be encouraged. So where on earth could there be a reasonable, rational reason for providing a right for exclusion for people simply because they're 65 years of age or over? And thirdly, Mr. Chairman, people may, of course, actually retire at any age. Some people retire as early as 50, 55, 60. And some, like me, and I'm 66, don't intend to retire for some time yet. So what on earth has the retirement age got to do with the ability of a person to do their duty to the community in respect of jury service? It's just, the reason just doesn't exist. And fourthly, Mr. Speaker, because 65 years of age is the superannuation age currently, what on earth has that got to do with this issue? That is exclusively an age which, so far, this country has adopted as the retirement age. And as I've said, that is only a notional age and not, for many people, a real age at all. So if people aren't, in fact, retiring very commonly at age 65, why on earth should they have a right to excuse themselves from jury service? And in any event, and fifthly, Mr. Speaker, the issue that is really relevant here is the one that's already in the Act in relation to an exclusion for health purposes. And that, in fact, is actually the reason that the Minister gave in respect to this. She didn't really talk about age. She talked about somebody who, for health reasons, was not able to and didn't want to contribute. And those are the real issues, the ones I read out at the beginning of my speech. It is not age itself that matters. And, Mr. Chairman, People aged 65 or more, like me, do not like being told that they are so old, Mr. Chairman, do not like, Mr. Chairman, to be told that because of their age there is something different about them that means they have to be treated differently in the law, whether it be for this purpose or for many other purposes at all. So therefore, Mr. Chairman, I have moved an amendment to delete section 10, which I think is appropriate in SOP number 33. I do not accept either that that section 15A2 would be improved by the Minister's SOP, allowing people to go on and come off and go on and come off this list. Just doesn't make sense. In fact, the whole thing about age should be removed altogether to solve the problem. That SOP would only make it worse, I believe. It's misconceived and should not be in the bill at all. Apart from that, New Zealand First has the greatest of pleasure to support this bill because it makes some very sensible provisions, and some of those I have mentioned. In addition to that, of course, it does provide for privacy of information regarding jurors, and that's something that's been needed for quite some time and is a very good move. And I think one of the reasons why there has been a bit of a bad reputation about being on juries is because that privacy isn't there currently. So some people resist jury service, not for the reasons that the Minister gave relating to age, or maybe they're getting a bit past it, which I don't accept, and neither do they, by the way, but it's for other reasons altogether. And the Baker case, of course, demonstrated what those reasons can be. And in that case, a person who represented themselves obtained a jurors list, sent a letter to a woman juror making romantic overtures. That should never have been possible. And records show that 4 out of 5 people called for jury service seek to avoid it. And it's got nothing to do with age, nothing whatsoever to do with age. 67,938 people failed to attend for the purpose in 2009. So anyone who tells me that age has got anything to do with any of that, I think is dreaming. The reasons are more about privacy and about the need to protect details of jurors than about anything else. So part 2 of the bill, for those reasons, is very, very important. And those are the main reasons why New Zealand First believes this bill should be enacted. So if anything, however, we would prefer to see tougher measures and tougher penalties to ensure the protection of jurors from being contacted by an accused person and especially by a convicted person. And that happens as well. So I don't think the bill goes far enough in those respects, but it goes too far, goes too far in part 1 in respect of the age issue. Thank you, Mr. Chairman.
The Honourable Judith Collins.
Mr. Chair, yet again I am rising to speak about